Hi, welcome. I'm Jonathan Rubens. I'm the editor-in-chief of Business Law Today. Welcome to Business Law Today's Author Spotlight series, where we shine a light on some of the outstanding articles that we've posted to the site in recent months. We are featuring some of the authors of these pieces and learning more about a whole bunch of different topics on Business Law Today. With me today, I'm excited to have Lenore Benessere, who's with D'Amato and Lynch in New York City. Lenore and her co-author, tell me who your co-author was one more time.
Robert D. Lang.
Robert Lang are the authors of a piece on a topic that is familiar to lots of us. It's the use of digital assistants, virtual assistants in the workplace. And I say it's familiar because we all have seen numerous commercials from folks like Amazon about the Amazon Alexa,
Yes.
Google's competing product. And who would think, we lawyers would think that this may present lots of problems for us in the workplace. So that's what the article's about. And Lenore, let's get right into it. Tell us about what really started you thinking about what kind of problems these would cause in the workplace. And are you starting to see people use digital assistants and thinking about these things? And what's coming up with these devices?
One of the ways that we began thinking of this as a workplace assistant, not just an assistant that we have at home, is that in November of 2017, Amazon.com issued a statement saying that they were looking to start seeking businesses as their new clientele with the introduction of Amazon Alexa for Business. So in that way, we know that Amazon is going to be targeting businesses, and we were concerned about the ramifications that it might have to have an Alexa or an Echo in your office space, in your conference rooms, in your own individual offices, because these devices, we know, are recording everything that we say. They're called the second generation of speech recognition technology, and what that means is that you do not have to press a button in order to engage, which is one of the things we find so useful. You can speak to Alexa across the room and have her play music for you, or respond to a search inquiry without pressing anything. But because of that, the very functionality of it makes it necessary for Alexa to be always listening to what you're saying and waiting for that wake word, such as Alexa.
So what that means is, of course, we have to pay attention to the default settings for these devices, what they're doing by default, what they can do, and remember how we've set them or how we've configured them to operate. Now, I assume that there's also problems that this raises for other ways that they're interacting with us in the workplace, such as what about the storage that's associated with the devices, or what about user voice interaction and those features? What kind of problems do you see from those kinds of things?
Well, we were thinking really for lawyers themselves and having them in our workplace, it isn't as much of an issue as it is for our clients, because for the most part, the communication that a lawyer has with their client or the research a lawyer does is protected by the work product rule or by attorney-client privilege. So what we're really concerned is about the impact that it'll have on our clients, in the terms of litigation or in contract negotiation. And we know that the search inquiries that are on our Amazon Alexa can be accessed through the settings. And you can actually take your client to the settings of their Alexa app and replay in their own voice the recordings. So number one, we know that the search inquiries are being stored in the cloud, which refers to like a virtual database where all of the search inquiries are. But what's more interesting is that for a few moments before the search inquiry and a few moments after, that is also being recorded.
Right.
So it's not just the search inquiry itself, but it's those few moments before and after that Alexa is recording and storing in the cloud.
All right, so some of our clients may be using these devices by design or otherwise to record conversations that are taking place. And that, of course, invokes laws all over the place. Lots of states have laws about the ability to record conversations.
Right.
So how are businesses dealing with this, or how should we be advising businesses to deal with compliance with the laws about recording conversations?
Absolutely. So right now there's no laws in the books specifically with the recordings from Alexa. We do have laws in the books regarding wiretapping or just recording conversations in general. And there's usually two schools of thought. There's the one-party consent rule and two-party consent. For the most part, the country is a one-party consent rule, which meaning one person to the conversation has to agree that it be recorded in order for it to be legal and permissible for it to be recorded. In two-party states, and there's only 11 of them in the country, such as Massachusetts and California, both parties or all parties to the conversation have to consent for it to be recorded. So it would basically be only for conversations like this,
right,
where we know that it's being recorded. Maybe it's a video deposition, maybe it's just informal that you want something recorded and a record of it, but you cannot go in like you see in the movies with somebody being wiretapped and having something concealed, because it has to be consent for everybody.
Right. I practice in California, and I'm aware of being in a two-party consent requirement state, and I can't see how I could, as a business, practically use a device like this in the business setting all the time and still comply with the law.
Absolutely. In terms of the user agreements, you might be agreeing to some things there that you weren't aware of. In terms of your own recording, I think that's how they get around it, that your own recording can be stored on the Alexa app. Right. But in terms of having Alexa out in your conference room and recording the conversation of people or attorneys that are meeting there, that really can't be done in a two-party state, at least legally, and it cannot be discoverable later on in litigation, which is different than a one-party state. But I think the issue that our clients should be aware of is that these devices do not need to be concealed. It's not like with what you see in a movie where somebody's being wiretapped and all the microphones are hidden somewhere. Right. This is an iPhone that's sitting on your desk at work, or an Echo that's there, and nobody really would think that those devices have these capabilities. So we want to make sure our clients are aware of it to protect them, but also for us to be able to use these capabilities as a defense in litigation. For example, our firm has discovery demands for personal injury actions because it's important to know what search inquiries a person has asked Alexa. If you take a personal injury action, have they asked about their commute time to work when they may have a lost wage claim? Have they requested information regarding gyms in their area when there's issues as to whether they could be walking and completing that type of activity?
Sure, and I should have noted that you're in a business litigation practice, and as you're pointing out, many lawyers have their canned set of questions and contexts that they use when propounding discovery. And along with all the other technology and devices that you've started to think about when you're working on your discovery requests, here's yet another set of things we need to incorporate into those requests, right?
Right. Just because you should be concerned about it, the other side of the coin is to use it defensively, and that's what we're seeking to do. I mean, even Fitbits and your Apple phone under the Health app also has this capability of tracking how many steps you took in a day. And sometimes, even if a person is being truthful and honest in their deposition testimony, these devices can be used to refresh their recollection about events. And it's important for us to both warn our clients of its impact and also use it defensively to help make sure that they're being fully defended against these claims.
Right. And with other technology, with other innovations, clients need to be advised and remember that there's a lot of different aspects of this to think about. First of all, there's a lot of features for these devices, and some of our clients might not even, as you've just pointed out, be aware of what the features are, right? And be using the features without knowing it. And then there's also those terms and conditions, those nasty terms and conditions. Like, have the clients actually thought about what's in there and what they've agreed to, right?
Have they read it? Have any of us really read every single thing? And one thing to note, though, with the Amazon Alexa, so because they're having this Amazon Alexa for Business and they've launched it in this way, we may not always, as attorneys, have a choice as to whether we're going to see them in our conference rooms or in our offices. That might be something that the infrastructure of our firm wants to start integrating them, because it can help. For example, they say you can use Alexa to report an IT issue. If your printer's not working, you could just tell Alexa to report it to your IT department or to have a conference room scheduled for you. So we may not have a choice not to have this technology in our offices. So what we can do is there's a little mute button on top of Alexa, which doesn't allow her to function quite as well because you cannot speak to her, but it will protect your conversation and make sure that it remains confidential if that's what you're looking for.
And I assume that we're going to see other kinds of virtual assistant, digital assistant offerings. Google has a competing offering. Yes. We're going to see others as well, and we're going to see probably more variety of features targeting the business community.
Absolutely.
So the discussion about inadvertent use, not paying attention to terms and conditions, it's a long one, and it's one we've had for a long time now about all kinds of offerings and services, cloud providers and so forth. And it's been in the news yet again just this week with the testimony in Congress from Mr. Zuckerberg of Facebook, and attention finally from some of our leaders in Congress about what exactly consumers in America sign up to. So what do you think about this renewed focus or this continual focus on cybersecurity and data breaches? Are we starting to see concern that's specific to the use of the digital devices? Have we seen any notable breaches yet around the devices? Or What can you tell us about those kinds of
At this
things?
point, there hasn't been any notice that Amazon and the cloud, where they're storing all this information, has had any substantive breach, but that is something we should be concerned of, because it's not always just information that we think is for credit purposes, such as your date of birth and your address that somebody could use to take out credit in your name, but we should also be concerned that our search inquiries, which is what Alexa is storing, might be the subject of breach, and what impact that could have on us or on our clients.
I should refer everybody back to the article to read more about the topic. Take a look at the image on the website. We have a wonderful little robot that folks noticed to make sure we draw your eyes to this story and to some of these issues. And I'm sure we'll see more around the areas of digital assistance, workplace use of technology like this, as the focus and issues around data breaches, cybersecurity, and privacy just keep growing and growing.
Yeah.
So thanks for being here today,
Thank
Lenore.
you so much for having me. I appreciate it.